Hello, people. Thank you very much. I'm doing an analysis today with respect to a case which we have, and I'm using this only for educational purpose. I want to analyze this. I will not mention the names, and so that you may be able to understand. Not okay with an understanding that we have data protection and matters which are in court, but I want to use specific cases. I mean analysis so that you'll be able to know which case I'm trying to work on. This is a case of stealing contrary to section 268. When you read, this is what it says: stealing contrary to section 268, subsection 1, as read with section 275 of the Penal Code. The name is given, and then these are particulars of the charge. It says, on the particular day at this location in this particular sub county in Nairobi County, you stole one item worth 30,000. Yes, that is it. And blah, 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 costing this much, the property of so and so. Now, and that marks the end. Then down we have other items that are given, but then we have just below we have the complainant's contacts and, of course, the witnesses attached to it. And so I want to analyze the question because I'm preparing cross-examination questions, professional cross-examination questions on this charge of stealing contrary to section 268, so that we may be able to understand, for the fact that I have been to remand custody and I found so many of the cases are of this nature, and many of them do not even know how to handle their cross-examination questions. Now you realize that when you are given the statements, pre-trial conference, during that time of pre-trial conference, you're given statements of the complainants. In this case, yes, complainants and witnesses and others that are going to support or corroborate the claim. But on this one, we only have one witness, who is the chief witness in chief, the complainant for that matter, or PWR. There is no any other person. This is the easiest, simplest case whatsoever. But you find somebody rotting in prison. So I decided to come up and help them to sort out their cases. And incidentally, this is a very young boy, 21 years old. When you start taking yourselves to court on very minor issues at this age, then you have a problem, because where we are getting to, you will spend most of the time in court. These are things we need to take to elders, mediation, church member, and all that, and discuss them and sort them out. Let's go. This is what the statement says. I am the above mentioned wherever name, adult, aged 21 years old, single, and a resident of this particular place, currently working with this company, located at wherever I am, of sound mind and competent to record a statement. That is one very important thing you need to understand, because when the questions come, you will never stand and say that one I don't know, I can't remember. You have already made a commitment that you made that statement in sound mind and competent to write a statement. What does this statement mean? It means that what you have done, you have bound yourself to it, you own it, and in your sober mind, you did not have a piece of insanity, you were not drunk, you were not stressed, you were good to go. In fact, you made your decision perfectly well, knowing that you are making it under oath. In as much as it is not in court, this already begins an oathing statement. And so we go to the next step. And so let's now proceed to the heart of the statement, after confirming that he's perfectly well in sound mind and he has made it with his whole one decision complete. Now he said, I do recall. That is, now you have a perfect memory, because what happened is past. So he says, I do recall that, well, on this date, at around this time, I was at this place in a residential house where I had been hosted by a friend. And so his location is in a friend's place, not his own home. Before leaving the house to purchase food from a nearby shop, so he left to go and purchase food, and I left so and so inside the house, where he remained lying on the bed at that time. And then his item was connected to a charger, while the whatever item, also another item, wireless, was placed on the table inside the house. And his friend, who was lying on the bed, was also on the bed next to the table. Now, leave alone those facts. We have seen that he is going out to buy the items and he has left his friend on the bed lying. So with these items that he has specified on the table. Now, before leaving, I locked the door from outside, and proceeded to the nearby shop. So that means the person inside cannot leave. After a short while, I returned and found the person who was on the bed lying inside the house, lying on the bed. Upon checking what he left on the table, he discovered that they were missing. However, the wireless, blah, 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 and that's what are still on the table. But his particular items are missing, and the house is still was locked when he came in from the outside. And the other person is still lying in the same place. Immediately, when I asked the person who was lying on the bed about the whereabouts of my laptop, or whatever, sorry, and that other item, he informed me that he did not know where they had gone or how they had disappeared. He also confirmed to me that no person had entered into the house. His explanation did not account for the disappearance of that property. Now, that is the statement of that person. Having heard that, now let's get to understand what this case, because now the person, suspected person who was lying on the bed, has been charged with the offense of stealing contrary to section 268. Now let us listen and see what the section demands. So section 268 outlines what counts to be that offense of 268. It defines, because in another forum I say there's a difference between stealing, contrary to section 268, subsection 1, subsection 2, and the rest. And we have also stealing a motor vehicle, stealing. Several items are given according to their sections. Now, for this section, this is what demands for it to be. Now, property capable of being stolen. Something that you must move. It must be movable on the legal, or for it to be able to fit the legal definition of section 268. So the item must be movable. In this case, we were talking about, the issue here is simply a laptop that was stolen. And then the other thing is, you just don't move and return. So the elements that has to be proven is the taking and conversion must be permanent. That is, you took it to another place permanently without an intention of returning it. Okay, it must be movable. It must have taken it without an intention of returning it, and that movement was caused by the accused person. That is, he took it without the intention of returning. He wanted to convert it for his permanent sale or something like that. And then secondly or thirdly, he had no right of ownership. That is, he did not claim right of the item. And then his intention was fraudulent. That is, to gain out of it, to permanently using it for monetary gains and all that. So to deprive the owner permanently, intentionally, or the act is done with one of the specific statutory intents, such as permanently depriving the owner, using the item as a pledge security, or using money at one's own will, even with an intent to repay later without the consent of the owner. That is now stealing, contrary to section 268. Now, this is now where the thing becomes very thick and crazy. This one, you must have had a practical vision evidence of the movement. It's not a mere suspicion. Let's go to Evidence Act section 63. Now, Evidence Act, Kenya Law, Cap 80, Section 63 provides that it mandates all oral evidence must be direct. What does that mean? That the person giving evidence, testimony, is the person who saw. So you are saying, I saw the movement. I saw the movement, meaning it forms the legal basis of the hearsay rule, that it's not something that you heard, but you saw. By requiring a witness to speak only for personal sensory perception, you must have a direct information about that. And then direct mandate, that's what I'm talking about. Oral evidence must in all cases be direct evidence. Then visible facts, I must have seen it. You must have seen the movement. You must have seen that laptop, that item being moving from one place to another permanently and never to return again. Auditory facts, audio, you must have you must come from a witness who personally heard the facts. While these are on a different, but on this case, he must have seen. And that is basically forms the basis of this case. You must have seen, you must have heard. And since it involves something, a movement of an item, there has to be somebody who saw the movement. Leave it at that. When you listen to the statement, he says that he locked the door outside and he went to purchase some items. Then when he came back, he found out that his personal items were missing, while the guy he had left in the house was still lying in the house. And the door, when he had gone to do some shopping, he had locked or closed the door from outside. So there is no signs that this guy moved out. So how they disappear? Then the suspicion is very simple, that this man is the suspect. We don't know whether he slept and somebody came and picked and left. That one we can't tell. And we also don't know that he took the item and left or he hid in the house. Nobody knows, but that is something that has to be established by the court. Now, because this case only relies entirely on suspicion, let us listen to what the law says about suspicion, and this is where we look at precedents, inferences, and all that, so that we may be able to establish what exactly happened. Because there is no fact of whoever took upon this case or took upon these items and took them away. There are chances that this young man was lying and somehow slept off, or the other guy came and took them and sold them. Nobody knows. Or even this other one might have gone with them and sold them. So there are three different issues. Either the one who went shopping came and took them without this other one knowing, or somebody else came from outside, opened the door, and went out with them, or this man, he could not have left the house because the house was locked. So where is the suspicion? Let's see what the law says about suspicion. Now, I want to look at two cases. Two cases. Let me say three cases when about precedences talking about suspicion. Sawe versus Republic, the year 2003, Kenya Law Report 364. It says the Kenyan Court of Appeal firmly established that a criminal conviction cannot rest on a mere conjecture or strong suspicion. Guilt must be proved through solid unbroken chain of evidence. So suspicion is not grounds enough to convict somebody. Remember, the main key objective of the prosecution is to prove every element beyond reasonable doubt. It's nothing to do with suspicion. Mary Wanjiku Gishira versus Republic in 1998, Criminal Appeal 17 of 1998 says, highlighted that when a prosecution case leaves gaps or relies on weak circumstantial connection, weak circumstantial, like for example, I left him in the house, he was lying down, the accused remains a mere suspect, and courts must acquit that person. That's very key. Mere suspect, and courts might acquit that person. So we develop now cross-examination questions based on these facts. So for this one, I am guaranteeing and I'm very much sure that the accused person is going to be acquitted. Neema Mwandaro Nduria and Republic versus Republic, he says, reinforce that where evidence only points towards an opportunity or speculation, suspicion alone cannot found a valid conviction. So this case is a sure bet that is going to be thrown out of the windows. So we derive our cross-examination question based on the law and precedences so that we make sure our client is safe and sound.